Okay, friends, if I could have everyone's attention. Thank you. We'll clink some glasses. Thank you, everybody. I'm Tim Chapman. I am president at Advancing American Freedom, and I am thrilled to see so many friends in one room. Thank you all for being here. What a great group. I'd love to say thank you to Justice Alito for being here. Such an honor for us to have you here. He's the only man in this room whose opinion really matters. So we will listen carefully. I want to thank John Malcolm. Round of applause for John Malcolm. John and his team came over to AAF in December. I think many of you know about it. Many of you read about it. This was a big deal for the conservative movement. It was a big deal for AAF. I'm so grateful to John and his team. I mean, these guys, they put on events like this that you all are part of, but more importantly, they are the backbone of the conservative legal movement right now and standing for principle at a time when principle is under attack. So thank you, John. I will be brief, and then I'm going to turn it over to John. I just want to say something very quickly that I hope is encouraging. So when we were, as we've been building AAF through the years, when we came upon this moment in December where we had the opportunity to recruit some of our friends from the Heritage Foundation, it was a big challenge and a big moment for us because to do this, there was a financial commitment. There was a long-term commitment to every person that came over. We doubled in size. We went from 16 people to 39 people. And so we had to take it very seriously, and we had to go out. We had to find the support to do it. One of the most encouraging things for me, as somebody who still cares deeply about the conservative movement, who still cares deeply about the principles that we've all been fighting for in this room for so long, was that when we went out and we took this to market to see if there were people who would help us do it, I thought I was going to have to go through this big wind-up routine, this big song and dance about what's happening on the right. Do you understand what's happening on the right? And as we went around and talked to people across the country and asked them to support this effort, I didn't have to do any of that. People across this country were way ahead of us and were paying attention to what's happening. And it's not that things are terrible on the right. There's a lot of great things happening on the right. You guys are a part of so much of it. But there is a tension right now on the right between principle and power politics. And we've got to find a way to negotiate that tension in a way that comes out on the side for good and the side for principle. And I did not have to do that kind of wind-up routine. When Mark Short, our chairman, was here, was across the country having to talk to people about this, he did not have to do that. When our founder, Vice President Mike Pence, was talking to people, no one had to do it. People understood. And I think that's encouraging. You all should take heart. Because what I'm seeing right now across the conservative movement is that people are thinking about what do we build for the future? And that's a great place to be. So one of those people building for the future is John Malcolm. Please welcome John up here to introduce our speaker.
Thank you, Tim. It's very kind of you. So welcome, everybody, to the Edwin Meese III Originalism lecture, which is going to be delivered tonight by Professor Sherif Girgis. We hosted, as you all know, this lecture for many years at the Heritage Foundation, and we are delighted to carry on that tradition at Advancing American Freedom. So we also we are also very honored this year, of course, to have Justice Alito with us. And I think it's actually very fitting because last year's lecturer, Joelle Alisea, was an Alito clerk. And this year's lecturer, Sherif Girgis, is also an Alito clerk. So our transition has been bookended by Alito proteges. And we are very happy that you are joining us. So in past decades, especially during the era of the Warren and Burger courts, some might have considered it very strange to have a lecture on originalism. After the New Deal, many considered originalism to be extinct, like dinosaurs or the dodo bird. But that is no longer the case. Originalism's comeback began with a speech by Attorney General Ed Meese to the American Bar Association in 1985, where he spoke about a jurisprudence of original intention, which has since been revised, thanks largely to the efforts of Justice Antonin Scalia, to original public meaning. Now, whenever I mention this speech by General Meese, I always give a shout out to Justice William Brennan. Attorneys general frequently give speeches to the American Bar Association, almost none of which are memorable. They have about as much an impact as a pebble being thrown off a cliff. But not Meese's speech. And that is because Justice Brennan felt compelled to respond. In a speech at Georgetown Law School, Brennan declared that a judicial philosophy based on original intention was the height of arrogance. He said it was impossible to discern what the framers would have intended in terms of confronting a case in the modern era. He added, quote, "We current justices read the Constitution the only way we can as 20th century Americans. The ultimate question must be, what do the words of the text mean in our time?" It was game on. And I am delighted to say that despite the efforts of living constitutionalists and common good constitutionalists, originalism seems to be winning. A solid majority of the justices on the Supreme Court today call themselves originalists, including one self-professed practical originalist who is with us here today. At one point, Justice Kagan went so far as to say, "We are all originalists now." Well, it seems that some practice it a little more than others. Tonight, we will hear from Sherif Girgis and hear his perspective on the future of originalism. Professor Girgis joined the faculty of Notre Dame Law School in 2021. A graduate of Yale Law School, he clerked for Judge Thomas Griffith on the D.C. Circuit and, as I previously mentioned, for Justice Alito. In addition to his law degree, Professor Girgis earned a master's degree in philosophy from the University of Oxford as a Rhodes Scholar. And just last month, he successfully defended his PhD dissertation in Princeton University. So now it's Dr. Girgis. He is the co-author of What is Marriage? Man and Woman, A Defense, and Debating Religious Liberty and Discrimination, which were published by Oxford University Press in 2017. And his articles at the intersection of law and philosophy have been published by many prestigious law journals and also prominent newspapers. We are honored to have him here with us tonight. Please join me in welcoming Sherif Girgis.
As usual, I have to lower the mic. Thank you, John, for that introduction. And heartfelt thanks to you and the Meese Institute for having me. This is a huge, huge honor for many reasons. First, because of Attorney General Meese. I'm a product of many of the ideas of the conservative legal movement, so I owe, like everybody else in this room, an incalculable debt to Attorney General Meese. I don't like saying General Meese. Attorney General Meese. And so I'm just honored to do any lecture that bears his name. I'm especially honored because of the former Meese lecturers on originalism, like my friends Joel and Josh and Kurt Lash and John Yu. That's an amazing roster to be following. And I'm also honored and a little bit embarrassed when I started learning who the guests would be. Justice Alito included. You were subject to my descriptions of cases, but those only lasted like 4 minutes because he doesn't need his clerks. And this is going to be longer than 4 minutes. And and also to Ed Whalen and Ryan and a bunch of other people. This is completely sincere. I was greatly relieved after learning the guest list when I learned that this would be at a steakhouse, because I thought it'll be worth your time no matter what happens in the next 35 minutes. So just keep in mind that the steak is on the way and the alcohol, I think, is being poured as we speak. So my topic is originalism and specifically its future. Even more specifically, my question is, will originalism over the next 20 years become the victim of its successes over the last 40? A very bright, cheerful topic. Now, that's a matter of prediction. And as Yogi Berra said, it's tough to make predictions, especially about the future. and I don't pretend to know how originalism will fare, but I'll offer my sense of what the answers might turn on, and I'll rule out some possibilities. To consider the movement's future trajectory at all, of course, you need to plot its past points. So I'll begin there with originalism's rise and recent triumphs. Then I'll identify the challenges created by those triumphs. I'll make a few negative predictions about what's not going to save originalism from those challenges. And I'll end with 5 possible futures, very briefly described. And I have to say, I'll sound a note of caution, which will occasionally sound like a note of doom, but it's not meant to be that way. So I think originalism faces threats. They're serious, but the note of doom is conditional because originalism will persist if it finds thinkers and actors capable of carrying on what giants like Attorney General Meese began. Okay, so start with the bright stuff, the successes. As this crowd needs no reminding, originalism attempts to root constitutional decision-making in the understanding of the Constitution's text at ratification. Its champions would say, as John Malcolm alluded to, that the method's been with us since the founding, and it only really needed a name after the Warren and Burger courts had strayed so far from it that we had to name it in order to restore it. That effort began with the work of scholars like Raoul Berger and scholar judges like Robert Bork and Antonin Scalia, and it was given political reality by people like Attorney General Meese. And as the quality of your stake tonight will confirm, the movement has done very well for itself. It has succeeded as an intellectual project and as a political legal project. Start with the academic side. 46 years ago, the word originalism did not exist. 40 years ago, when I was busy being born, only a few scholars would have embraced the theory, and it was viewed with scorn by every other scholar and by the very few judges who had heard of it. And today, originalism as an intellectual project is flourishing. It boasts defenders at the nation's top-ranked institutions like Yale, Harvard, Stanford, Chicago, Columbia, UVA, Georgetown, Northwestern, Notre Dame, Minnesota, etc. It's powered by centers at schools like the University of San Diego, like Joel's Center at Catholic University, like centers at other schools that I've mentioned. It's sustained by dedicated law journals, by an annual scholarly workshop, by fellowships for students and aspiring scholars, by summer seminars for students and judges, by clerkship academies like this one. Academic originalism is in full flower. So is what I've called chambers originalism. The method is well represented at every level of the federal judiciary and even now on some state Supreme Courts. I'm sure most of the 600 federal judges appointed by Republicans since President George W. Bush would identify as originalists. A majority of the Supreme Court identifies as originalists. And the court has delivered victories that originalist leaders have long sought. The court has abandoned the Lemon Test, by which the Berger court had given the Establishment Clause vague and overbroad contours. The court has overruled Bakke, which had blessed race-conscious affirmative action policies under the Equal Protection Clause. It has seriously injured, and may soon finish off, Humphrey's executor, which authorized the creation of executive agencies enjoying some insulation from the president. And in what my great friend and past Meese lecturer Joel Elisea calls the most important case since Brown v. Board of Education, the court overruled Roe, returning the question of abortion policy to lawmakers. Why not? Okay, the positive stuff ends there, unfortunately. These developments create momentum. And Chevron, right? It was constitutional. It's not constitutional. Anyway, okay. And Chevron, we got rid of Chevron. And also, like, the movement hasn't always wanted to get rid of Chevron, so it's a little complicated. But anyway, recently we've wanted to overrule Chevron, and it's gone. So Heller is also great. Heller is great. There's guns. You can get a gun now. Okay. These developments create momentum, but also challenges. They create challenges not for originalism as a theory, not for its intellectual justification, but for its practical viability. And that matters because originalism isn't just a theory. It's not like Platonism about math, which is the theory that numbers and sets and other mathematical posits have objective existence as abstract mind-independent objects. If you don't get what I just said, that's okay. Most people don't. I don't really. That's the sort of my point. The knowing Platonic number theory might be valuable in itself, But no one bothers to promote understanding of it by funding steakhouse lectures because it's not meant to affect the world. Originalism, by contrast, is not just there for contemplation, at least as a theory of adjudication, which is my focus tonight. It's meant to shape the world in high-stakes ways. And for that, it isn't enough that the theory be defended in journals and lecture halls. Originalism has to be taken up by judges, by the politicians who pick them, and by the voters who pick them. So originalism in this practical dimension depends on politics, and that contrast with Platonism is not an embarrassment to originalism or to Platonism. It doesn't mean that Platonic number theory is lame or that originalism is just a cloak for politics. As to originalists, in terms of their sincerity and purity of motives, I assume they're no better or worse as a lot than non-originalists. But I've certainly known personally originalists who were very clearly motivated more by the theory than by policy outcomes, or who liked most of the method's outcomes but stuck to it even when it cut against their politics because they believed the theory. My point is just that at the systemic level, unless originalism appeals to groups with political influence, it will lose political support. And in a system where the politicians pick the judges, less political support means less impact on judging. Again, it's to that political viability of originalism that I think several recent developments pose a challenge. First, political support for originalism might wane precisely because originalists have been so effective at maiming or lancing their white whales. Lemon, Bakke, Humphrey's executor, Roe. The fewer common foes left, the less urgency originalists in the world will feel to spend capital sustaining real-world support for the method. Of course, that problem could be overcome if originalism's influence on the court consistently yielded other results that were both broadly appealing and very easy to trace to originalism. But that brings me to a second challenge. The rise of an originalist court majority brings all the difficulties typical of any move from loyal opposition to governing party. It's easier for originalism, or really for any philosophy, to be in dissent. For one thing, governing parties get the blame for all the stuff people don't like. And for another, those in charge are confronted with questions their philosophy might not have answers for. As a dissenter, you get to pick your battles. You can speak just where your philosophy has something clear and compelling to say. So it's no surprise that the most memorable originalist opinions have been dissents, like Scalia's and Morrison on independent councils, in Lamb's Chapel on Lemon, in Casey on Roe, and so on. A governing philosophy, by contrast, has to find something to say on every issue that gets to the court. And sometimes it'll come up short because no theory, at least no meaningful determinate theory, will have answers on everything. Indeed, the fact that the court is majority originalist might actually make it likelier than ever to get cases on which originalism is inconclusive. Of course, it's always true that an apex court that selects for issues that split the lower courts will get hard cases, but an originalist court is likelier to get cases that are hard for originalists. That's because the lopsided cases, where the originalist outcome is obvious, might seem not worth the expense for the side that expects to lose originalist vote. There's an analogy here to what's called the Priest-Klein hypothesis, the theory that predicts a tendency toward 50% plaintiff victories in litigated cases on the ground that litigation in more lopsided cases won't seem worthwhile for the underdog party. That doesn't mean originalism does no work at the court. Recently, in a case about the CFPB's funding structure, just to take one example, 7 justices, I'm now realizing Justice Alito was not one of them, thought the original meaning of the appropriations clause was decisive, and they were wrong. They were terribly wrong. It was a terrible mistake on their part. But that was their sincere opinion. The court may even be advancing originalism by the cases that never get to it because people know what the outcome would be. A method's value is not exhausted by its footprint in the U.S. reports. But the point for our purposes is that at the court, originalism might get fewer chances to speak with the confidence with which it once boomed from dissent. And that matters politically. The less originalism has to say about litigated cases, the less motivated people will be to make sure that originalist judges are there to say it. Another challenge to originalism's practical viability also results from its coming to dominate the court. Originalism is committed to distinguishing the posited law from politics, and for good reason. While some legal questions are entwined with political ones, the overlap isn't total. And in our system, judges should defer to the political choices of lawmakers rather than do policy afresh. But that's easier to say when you're in the minority, and the court's majority is generating political outcomes you hate, as the Warren and Burger courts did from conservatives' perspective. But with the power of the fifth vote on the court, or a majority on a circuit court, comes the temptation to use it not to find the law by your theory's honest lights, but to bend the legal sources toward outcomes you like politically. And so I'm told conservative law students who are coming up in the shadow or in the light of courts full of Republican appointees tend to have less interest in formalist approaches to judging. Again, that doesn't mean the old school originalists have been pretending all along. Many oppose, even today, using originalism's newfound voting power to advance their policy goals, even very cherished policy goals. The great Ed Whalen is here tonight. He's a stalwart pro-lifer who opposes attempts to judicially compel protection of the unborn based on his reading of the Equal Protection Clause's original meaning. My point is just that originalism's salience for conservatives who are not yet convinced of the method will be weaker now that conservatives have power. Of course, politically desirable outcomes aren't the only thing that appeal to law students or politicians or voters. People also do care about the distinction itself between law and politics. In our system, that distinction isn't some bloodless theorem of legal philosophy. It reflects a potent ideal of popular sovereignty, the view that it's for the people to make policy choices, not for unelected judges. But here again, originalism's success might undermine it. For while it might have been easy for the public to accept in the abstract that sticking to the founders is doing law and going by modern values is doing politics, the question is no longer abstract. Term after term, the public is seeing the concrete results of having a court that identifies as originalist. And for the public, the temptation will be to assume that those results reflect only politics. For what strikes the public when the outcomes are concrete is not the legal niceties of the court's analysis. Most Americans don't read majority opinions, with apologies, Justice. They don't see which passage of Blackstone or the Federalist Papers or which entry in Black's Law Dictionary the court invoked. And they never will. The public just sees that abortion won or lost, that affirmative action won or lost. And all it knows besides that is that most of the court was picked by Republicans. So the public is liable to infer, with the help of a press eager to encourage this, that the justices acted on their political views after all. While no justice is perfect, I think the charge is unfair, but it's also, I think, inevitable. Of course, the public's impressions could be different if the court consistently ruled against the conservative coded outcome, or if the politics of outcomes seemed random, but that isn't likely for an originalist court, even if the court never cheats. For while our rival constitutional methods and political ideologies are distinct, they are correlated in ways that shouldn't embarrass anybody. Originalism, which tries to root doctrine in laws and traditions adopted in the past, will often overlap with political conservatism, which after all seeks to conserve. The link is even tighter on the other side. Living constitutionalism, which seeks alignment with present needs and values, will overlap with progressivism, which seeks much the same. Of course, there isn't perfect overlap between either legal method and political ideology. We have progressive originalists and conservative non-originalists. Criminal defendants fared well with Justice Scalia, though his politics favored law and order because he thought originalism favored the criminal defendants. The court appointed by the pro-life party, and which gave us Dobbs, also recently gave those who were seeking restrictions on abortion drugs a 9-0 defeat on Article 3 grounds. Still, the public's overall impression will inevitably be that what the originalists do when they take over is politics, not law, after all. And so the one politically appealing general promise made by originalism over and above specific white whales like Roe will seem to have been broken, will seem to be undermined by one of originalism's triumphs. Again, not because the justices are being dishonest or originalist thinkers had been dishonest, but because the public won't distinguish legal from political grounds for decision, and the two will correlate. Finally, several of these challenges created by originalism's success in the real world, especially the fading of its contrast with other methods and of its promise to constrain, would only be reinforced, I'm sorry to say, by its evolution in the world of ideas. Academic originalism's instructions to judges have become, if anything, more muffled over time, And for academics, the judicial constraint rationale is basically on its last legs. To unpack that a bit, early originalists, as John mentioned, thought courts should resolve constitutional cases by appeal to the founders' intent. Over time, under the pressure of critiques, scholarly critiques, most originalists went from caring about framers' intent to caring about the text's original meaning. And then they also distinguished original meaning from expected applications. The question wasn't what James Madison thought a text would require, but what the norm it communicates in fact requires. And these changes led originalists, like Professor Steve Smith, and critics like Professor Tom Colby, to argue that the theory had lost its flavor. They thought the so-called new originalism, far from tying judges' hands as originally promised, could justify whatever reasoning and outcomes the non-originalist heart desired. Any meaningful difference between originalism and its rivals, according to them, had collapsed. After all, the original meaning of a lot of texts like due process and the freedom of speech seems broad and open-ended and maybe even value-laden. Contemporary originalist scholars have answers, obviously. Most draw a contrast between interpretation, which is about identifying the meaning of the words, and construction, which is about using doctrines or other devices to get from vague meaning to concrete outcomes. Some argue that in the construction zone, we should have recourse to the text's original function, or original methods of interpretation, including default rules for dealing with gaps in the text. Others invoke the general law as lawfully changed, which is some function of the text and interpretive conventions and common law or general law or other unwritten background principles that might be presupposed by or incorporated by the text, and later changes that are ratified by the rules of legal change at the time, rules that might themselves be unwritten. Short, academic originalists have plenty of answers about how to handle open texture, but in a way that's the problem. They have all too many answers, thanks to another success I mentioned earlier, which is the growth in the number of originalist scholars. From that growth have stemmed widely ramifying theories and ever more complicated theories about how to specify originalism beyond or besides a commitment to original meaning. It's too early to tell how much those theories, which are mostly skeletal at this stage, will converge when they're filled in. But I doubt, at least, that they will bring the degree of constraint sought by early figures like Judge Bork. I doubt that the unwritten background principles or interpretive conventions or customs that take over when text is vague will greatly constrain judges. In fact, initial work might suggest the opposite. Originalist Professor Sai Prakash has argued in recent pieces that spirit, intent or purpose or function, and the inconvenience doctrine, an instruction to avoid bad consequences, played crucial roles in interpretation for the founders. He thinks the founders allowed moral or policy or functionalist considerations to guide the choice among candidates for original meaning, and maybe even sometimes to trump the most natural reading of the text. Other originalists, like Professor Kurt Lash, another Meese lecturer, have suggested that the original methods of interpretation were just too conflicted to deliver any clear guidance when the text is open-ended. The court has taken still another approach to dealing with limits in original meaning. It's turned to history and tradition. That phrase refers to long-standing or widespread practices of political actors, presidents, congresses, state lawmakers, state executives, sometimes state courts. For example, the court has said that Congress can't compel commerce under the Commerce Clause, partly because it traditionally hasn't, or that the president has special authority when it comes to recognizing foreign powers, partly because presidents have long acted as if they do, or that the states may pass a certain gun law because they long have, or that they can't because they haven't. After some initial skepticism, I've come to think this response to open-ended text is justified for some areas of law, but I also think reliance on historical practice won't constrain very much either. For in most cases, the practices cited don't reflect attempts to make or clarify constitutional law explicitly. They're ordinary regulations, a speech restriction here, a gun law there. And the court just assumes that the authors of those ordinary laws had a constitutional principle in mind that explained why the regulations they were adopting were lawful, an unspoken principle that we then try to discern by triangulating from those ordinary laws. In other words, political practices, history and tradition, don't wear their constitutional reasoning on their sleeves in the way that judicial precedents do, and they don't state constitutional law directly in the way that the canonical text itself does. As a result, I fear, synthesizing these practices and teasing out of them a principle to guide new cases will often require normative reasoning far more than the search for a precedence holding or a text's ordinary meaning. The best counter-argument is by Joel Alisea, and you should read that too. So while it's too early to tell for sure, I suspect we will see at best no change and most likely a decline in originalist theorists and courts' ability to find general constraints on judicial discretion. I think originalism does still differ from other methods, but the contrasts are harder to state in terms that are both general and informative, and that makes them harder to sell to the public. The remaining contrasts tend to fall into two categories that just will not excite a crowd. First, originalism, I think, still gives different answers to questions about this or that legal issue. For example, the original meaning of the recess appointments clause probably rules out some of the recess appointments upheld in Noel Canning. But such contrasts on specific issues are narrow and they're contingent on close historical argumentation. Then second, there are some across-the-board differences, like how intensely originalists search for evidence of original meaning before calling it a draw and moving on to other criteria. And those are consequential, but they're vague matters of degree. So those too can't be captured in snappy formulas or political slogans. Again, those difficulties don't prove originalism is unsound. Even if modern originalism proves less simple, less peremptory, less useful and polemic against rivals than Judge Bork's originalism, it wouldn't for all that be less principled. It could be both true and complicated. The problem, again, is about the political viability of an originalism that's hard to distinguish easily from its rivals. Religions that merge with the ambient culture soon see empty pews, and schools of thought, I fear, do the same. Above all, I think there's a selling point that originalism will never get back. It's lost the ability to reject upfront and wholesale a certain style of reasoning, which Justice Scalia, when you look back, sold originalism exclusively as a way of avoiding. The entire argument in his book, A Matter of Interpretation, in the lecture in that book, was about avoiding common law reasoning, which he thought was anti-democratic when it's applied by unelected judges to a legal text. I think something like common law reasoning, with its heavier reliance on normative judgments, is needed for applying many of the non-textual criteria that originalists have turned to in the presence of vague text, like constitutional backdrops or general law or customary norms of interpretation or history and tradition or what have you. As a result, in fact, most academic originalists now reject constraint as a rationale for the method and do so proudly. So does Justice Scalia's successor as the court's originalist scholar jurist, his own former clerk, Justice Barrett. So on this matter too, on the method's justifications, originalists have splintered, with different figures appealing to, variously, the judicial oath or the natural moral law or the abstract nature of law for their normative hook. Compared to the old promise of tying judges' hands, I think these justifications are hard to sell for senators, presidents, and voters. What all these challenges show, I think, is that originalism's astonishing rise as an academic and political movement in tandem depended on an unusual and maybe it will prove fragile set of factors. There was great overlap between theoretical justifications and political motivations. Both were about tying judges' hands. So the theory gave honest intellectual cover to the politics, and the politics gave muscle to the theory. The method's abstract, general promise to keep judges doing law, not politics, got a boost from its more concrete implications, like overruling Roe and Bakke. And the method was in exile, giving it the frisson of an insurgency in law schools and shielding it from the blame and complications that beset any governing party. And now none of that is true. Womp womp. Okay, so possible futures. Okay, what does the future hold? I don't think originalism will get back its stark contrasts and bold promises by suddenly finding new determinacy in the text's original meaning. I think there are too many provisions that were not even originally meant to do their work through the everyday meaning of the words. Think of phrases like due process of law, the freedom of speech, the executive power, and so on. Everyone agrees that those phrases point you to something off the page. Pre-existing norms, constituted partly, but maybe not entirely, by historical practices that judges will have, I think, greater discretion in reading than they would in reading a detailed statute. Not only do many cases turn on spare texts like those, in many cases, even originalists would rule on structural grounds that have no text on point at all and therefore no original meaning to work with. Take the recent presidential immunity decision. So for all those reasons, a renewed push to just stick to the words on the page will not, I think, bring the determinacy and rhetorical power that originalists once sought. So what will become of the method in practice if that one negative prediction is right? I don't know. I do theory. I can tell you that I think a certain type of originalism, called original law originalism, is roughly right, and for roughly the natural law reasons given by scholars like Joel's colleague Kevin Walsh and my colleague Jeff Pojanowski. As an academic, I'll keep trying to ask what's true and articulating and refining my best efforts at an answer. But rather than end on that self-righteous shot from the ivory tower, I'll close by sketching at least a few possible futures, 5 in particular. Okay, quickly. First, at one end of the spectrum, the grim end of the spectrum of possibilities, originalism might vanish from public life. Sorry, Sheldon. Maybe the label goes, or maybe it sticks, but it becomes synonymous with political conservatism. Not just for the critics, as has been true for a while, but in the minds of adherents and the general public too. In this scenario, originalism as an apolitical approach to judging might survive for a time in the academy, but it would become inert. Different in style and content and in its glamorous past, but no different in present impact from Platonic number theory. And so eventually, I think, the funding for centers and fellowships and steak dinners would dry up. Okay. A second possibility, will not happen. We're just starting the worst case scenarios. And I love guns. Okay. A second possibility, I've actually only shot a gun twice, and one of the times I was bleeding after I shot it. I had given myself a literal gunshot wound, but it was only because the thing that you pull back, it had nicked my thumb. What's it called? Yeah. Okay. A second possibility. I know, no true conservative. A second possibility at one step removed from the first is that originalism comes to live a double life, meaning one thing in the academy and something altogether different in the arena. Of course, there's always been some difference between academic and chambers originalism, given the different aims and resources and interests and needs of scholars and of scholarship and judging. But maybe the gap grows. Maybe the same label comes to denote political conservatism in courts and something more complicated and less politically interesting in law school offices. The two could remain linked for mutual advantage. The purely political thing getting intellectual cover from the academic getting money from its apparent, but merely apparent tie to the political. All right, but I hope not. Okay. A third possibility, slightly sunnier, is that originalism gives way to an idea it was once allied with, a norm of judicial restraint, or what's often called Thayerian deference. Thayer was a constitutional theorist who said judges should effectively under-enforce constitutional limits on political actors. They should invalidate a political action only when its unconstitutionality is beyond reasonable doubt. Early originalists sounded Thayerian, but over time, most came to think this was unjustified. The goal should not be under or over enforcement of the original meaning, but enforcement, whether that meant upholding or invalidating political action. No thumb on the scale either way. But if this more assertive approach has faced the challenges I've canvassed, I think judicial restraint might have the mirror image advantages. It is simple enough to be chantable. Its tie to popular sovereignty is palpable to the public. And so the country might, you might imagine, enter a truce, requiring both sides to under-enforce their revision of the Constitution to gain the benefits of the other side's restraint. But because nobody loves unilateral disarmament and only one side at a time can really commit to this path, it too may be unlikely. A fourth possibility is that Chambers originalism becomes more like academic originalism, but survives as a political project anyway. As I've said, academic originalists have made originalism less distinct from common law reasoning, but some differences remain, including differences of degree and style. Perhaps judging for legal conservatives will feature more normative reasoning than the early originalists hope, but will still be more constrained than the living constitutionalism favored by progressives like Professor David Strauss. Maybe, in other words, conservative common law's normative leaps will be smaller. Maybe its presumption in favor of existing traditions and political choices will be more pronounced. Maybe these differences would be recognizable enough to the public, or half the public, to seem worth spending capital to preserve. In that case, the decades-long rhetorical reign of the simpler and bolder originalism of a Bork or Scalia would have made a difference, but not the one they intended, and not one easily captured in a slogan. It would have tamed judges' instincts and temperaments, and that's not nothing. A fifth and final possibility, the stake is on the way, is that originalism is reborn, or rather it undergoes a kind of adolescence, a major and publicly visible change that somehow still preserves their identity. Originalism's identifying commitment, I think, is that the law made by the text adoption is supreme, and that changes to it must be sanctioned by recognized rules of change. No officially unauthorized changes just to keep up with the times. And I noted that while its lodestar has been original meaning, it's now clear that meaning isn't all that's needed or all that's available. Interpretive conventions matter too. I've said that research into founding era conventions is early stage and that I doubt it'll restore early originalism's starkness and bold promises, but maybe I'm wrong. Maybe it will emerge that under the original conventions for interpreting the text, certain moves were in and others were decidedly out. That the differences can be captured in terms the public can digest. That those differences promise results not yet realized that people care about, more white whales. Or that the differences matter to the public in a way that transcends particular outcomes, as the promise of finding and not making law did. And that the method would be distinguishable from policy reasoning, even for a public that doesn't read majority opinions. If so, it will take great discipline to develop. In his book After Virtue, Alistair MacIntyre closed his study of upheavals in our moral culture with words of uncertainty that were laced with hope. Alluding to the religious founder whose monks are credited with preserving the treasures of Western civilization through the Dark Ages, MacIntyre wrote that we are waiting for another, doubtless very different, Saint Benedict. Well, at the risk of some melodrama, and on a smaller scale and with slower stakes, we might say that legal conservatives, facing the changes wrought by their own success, are waiting for another, doubtless very different, Judge Bork and Attorney General Meese. Thank you.
Sherif, come on up. Gonna have a few questions. Come on up. Sorry about that. So I have to say that other than possibly the fifth of your possible futures, they were all decidedly depressing.
I aim to please.
That's okay. Aiming to please is fine. I guess I'm a little less critical than you about tradition because, there are gaps in the Constitution. You're right. We can't get inside the heads of the framers, but it's the next best thing, it seems to me, to fill in those gaps. There are cases like the immunity case that I think pose unique challenges to the court for all kinds of reasons. I guess I want to pose a totally different question to you, and then we'll have time for two or three questions after that. So you're saying that the public, cares about political beliefs versus, adherence to the rule of law. Maybe there was a time, I'm older than most of the people in this room, but even before I was born, where people made those distinctions. It seems to me for quite some time, the general public has not cared about, well, gee, what was the reasoning of this opinion? They've cared about, did I like it or didn't I like it? The newspapers certainly feed that. You have the living constitutionalists who, it strikes me, have always cared a lot more about, is this delivering the goods? You have people like Sai Prakash, Jack Balkin, who may have a point about that sort of thing. But one thing that strikes me as being very different and fairly recent is that on the right, you have people like Patrick Deneen, Adrian Vermeule, who are thinking much more, not is originalism the right methodology to constrain judges, but has it delivered the goods? Now, even if you look at it purely from that political perspective, the last 2 or 3 years have been pretty darn good. But it strikes me these are very, very impatient people. And frankly, you have a president who's feeding that a little bit on on True Social. Justice go, okay, so Justice Alito, Justice Thomas, were all praised the other day. But he said Justice Gorsuch and Barrett, whom he appointed to the court, are embarrassments to their family because they didn't deliver the goods. And it strikes me as if that is something different. And while the right has championed originalism for quite some time, you have some people who are very, very impatient, not at all satisfied with democratic norms, who want to deliver the goods to get conservative results. And that's what they care about. And that is a threat to originalism. And I'm curious to get your reactions to all that.
Okay. I think that's true. I guess one of the things there's a couple things going on. One is that some of those figures, like Adrian Vermeule, never identified as originalists, so they're not sort of changing their colors with the times. They're just saying that originalism served a limited purpose in their view, and now its purpose has been, it can be dispensed with. It's outlived its usefulness. One of the points in my talk, I guess, is that this temptation is going to be more, this inclination is going to be more widespread. For people who have not yet fully been convinced of originalism or formalist methods of interpretation in general, they will look around and think, wait a second, there are good outcomes you can produce, and we have the levers of power to produce them. So what exactly is the argument against that? And now, to their credit, people like Vermeule and Deneen, at least Vermeule and what I've read, acknowledge that there are values on the other side. There's something more than just getting the best outcome in the case right in front of you. There are the rule of law and settlement values. There are the popular sovereignty values of generally having judges defer to the political choices made by people representative of the public. But I think there's a need to make that moral case more forcefully. So one way in which I would be aligned with somebody like Vermeule and Deneen, but I also think like aligned with some of the most stalwart originals I know, like Joel Alsea, is thinking that at the bottom, you do need a moral argument. You do need to think that following originalism or whatever other method you think is appropriate will overall and in the long run best serve the common good of the political community, which is a substantive, moral, controverted thing. It's just that it's a less obvious connection than the connection between the common good and I'm just going to produce the result that I like the most. And so I would refer these fine people to articles like the one Joel wrote, From Within a Natural Law Perspective. Joel should have given the talk a second time, it sounds. That From Within the Natural Law Perspective, that say, look, I believe in the common good in its full-blooded Aristotelian Thomistic variety, and here is the way in which respecting the authority that the people have allocated to lawmakers as opposed to judges actually serves the common good.
Amen to that. We have time for a couple of questions. I just want to, we've got a microphone out there. We got come on up here. So it's Jack Fitzhenry. Let's, Jack, good to see you. It's a question.
Good to see you too.
It's on.
Right. Well, thanks very much for the talk. I'm curious, you're talking about the kind of strain of originalism that tends towards tradition and history. You say people like Vermeule and Deneen are not originalists, but somebody like Steve Smith is sort of more adjacent, right? And I've heard him describe himself as somebody who's originalist sympathetic. But he is, I think, written and argued for a long time about a more Burkean approach to law. And to the extent that you see the future of originalism leaning more into history and tradition, to what extent do you think there's the risk of it just becoming a kind of Burkeanism applied to American law?
Okay, so risk is a loaded way to describe it. I think that the only thing that clearly unifies everybody who calls themselves originalists today as a sociological matter is a commitment to following the original meaning of the text when it's clear. Okay, actually, even that's not all originalists, but that's the majority view. But that leaves it completely open what to do when the text is not clear. And that's what I was alluding to briefly with the talk of the construction zone. So interpretation is done. Now the term interpretation leaves open different possible outcomes, and we have to construct some implementing doctrines or something to get us from the vague meaning to a determinate outcome. In that zone, originalism as a theory that tells you to stick to public meaning is done. It's over. It has nothing more to say. And so now it's an open question what to follow at that point. And what I was alluding to in my softening towards history and tradition approaches in the talk, I think that one of the motivations for original meaning generally, which is a commitment to popular sovereignty, to the idea that ultimately the authority to make our higher law, and including the authority to concretize it when it's abstract and vague, belongs with the people rather than unelected judges, that commitment supports, other things equal, filling in those blanks in the construction zone by appeal to the people's practices over time. The theory would be, at that point, the original meaning of the text at ratification is not going to settle our dispute. That's our starting point. So now something after ratification and other than amendment will settle our dispute. So already originalists are going to be in an uncomfortable position one way or another. And now the question is, do you want that further something to be the judge's first best preference about political morality, or the political moral instincts reflected in the people's practices overall and in the long run, not reflected in the formal way of adoption of a text, but in the more diffuse way of adoption over and over of political practice? And I say between those two options, you pick the second. And I don't think that's a system in which Burkeanism swallows the rule of original meaning, but rather supplements it.
Yeah. We'll come over here, John. And then we'll take one more question after that. Behind you, John.
Thank you very much for that talk. I felt some of it was okay, boomer, but my question is, there are disputes still between originalists, right? And so they'll fight over what the original meaning is. Does the fact of their fighting over whether Burkeanism informs it, or whether the text informs it in pamphlets that went out to the general populace, does that undermine originalism, or is it just a matter of, if you're looking for the public meaning, what is the hierarchy of that is different for a bunch of originalists, rather than undermining it in the way that you are positing may not give the real answer?
Right. So I don't think by itself the existence of disagreement among originalists is a problem. It's not embarrassment to the theory. It might be a sign of good health of an intellectual movement, that it's got flourishing debates within it, that they share enough basic assumptions that they're able to have interesting questions downstream of those assumptions. I think all of that in general is a good thing. What I was suggesting in the talk is that if you were looking at the practice of originalism in the real world and thinking, we need some determinacy when the original meaning is kind of vague or unclear, or when we have to deal with sediments of precedent and so on, and you say, let's check in with the scholars, you'll be disappointed, because the scholars are doing what scholars do, which is massively disagreeing among themselves, drawing ever finer distinctions, asking about angels dancing on a head of a pen. Okay. And now it could turn out that when you check in with the scholars in another 30 years, it'll turn out to be okay. Like they were all just... That's right. Well, I like scholastics, but it could turn out they were all just trying to get tenure. They got their tenure, and now they've agreed that actually all their fine distinctions basically result in the same concrete outcomes. That kind of convergence after the fact, and I just got tenure, so I'm in a position to say this if it turns out to be true. I have no financial interest in being different from any other originalist at this point. Then it could turn out that the academics are coming to the rescue. They've got something to rely on after the original meaning runs out that's more or less convergent and will provide real guidance. The only other thing I was saying is, if you ask my prediction, I'd say it's not going to look that way.
Over here. Last question. Hang on. Mike's coming.
Hi, thanks for the lecture. You mentioned natural law theory twice, and I'm curious to see what role you see natural law playing moving forward. Is there an appetite for it practically, what framework do you see judges and practitioners using, and is it even a reasonable approach?
Yeah. No, I'm well past the phase where I could have a confirmation here. If only because I don't know how to use a gun. So, okay, natural law is said in many ways. Good scholastic beginning. Sometimes people use it just to mean the moral law that's natural. In other words, that we can naturally know and that doesn't depend on our choices and constructs. It's like there by nature. That's a very broad sense of natural. Often what they mean is a particular intellectual tradition of thinking about the content of that timeless set of moral principles. The Thomistic, Aristotelian, Platonic, some Stoic, something in that vicinity. Okay. In that sense of natural law, I think that sense of natural law provides the best foundation for thinking about the political common good and about the way to approach law so that it serves the common good. That tradition itself turns out, despite its reputation for being very morally picky in all kinds of ways, turns out to be pretty generous about what form your legal system takes, about exactly what allocation of lawmaking versus law interpreting your system chooses to run with. And so it's going to provide very wide latitude for the contingent facts of your own history and the choices your own people have made to settle the details about exactly what authority an Article 3 judge has, or a bailiff has, or a lawmaker has to make as opposed to implement the law chosen by somebody else. And so I think for the most part, the natural electrician gives you a very strong moral hook for caring about what settlement your people have chosen, because it gives you a rich articulation of how the flesh and blood, the well-being of flesh and blood human beings depends on this abstract thing called law running pretty well. But then it leaves a lot of the details to be filled in by your own particular history.
So, as was the case when we invited, oh, there it is. Okay. As was the case when we invited Josh Blackman and Joel Alisea to deliver the Meese Originalism lecture, I knew that we would get an outstanding lecture from Sherif Girgis. And so I am proud to present to you the Edwin Meese Originalism Award. And please join me in thanking you.